this year, and we are now recording. I'd like to welcome Jessica Lazur, partner in aviation and marine practice group leader, and Paul Johnson, partner in M&A and strategic joint ventures group co-leader, for today's presentation, buy-side diligence in an M&A transaction. You want to take it away?
Sure. Thank you. So I'm Paul. There's Jessica. We've worked together on a number of deals, and we thought that this might be useful. I believe we're probably going to have a number of people who've done deals before and some that haven't. So this presentation is kind of geared toward middle of the road. It doesn't dive in super deep, but at the same time, it's also not purely for novices. So hopefully we found the Goldilocks zone. Let us know, I suppose, if not. So big picture, what is due diligence? Well, due diligence, if you're, again, from the buyer side of an M&A transaction, you're buying a company, or you're helping your client, your company you work for, to buy a company. And it's the investigation of that business that you're buying in connection with that transaction or potential transaction. And there are various types of diligence. There's legal, which I assume is what most of us on this call are focused on. There's financial diligence, often led by an outside CPA firm, or maybe your in-house accountants, tax people. And then there's also business diligence, just to figure out, is there a business fit, channels, et cetera. We're going to focus mostly on legal, but not exclusively here in this presentation. Factors that can affect the diligence effort, well, the relative size and sophistication of the parties. If you're a relatively large organization and you're looking at a small one, you may have some frustrations as they try and respond to your many questions. Whether the buyer is strategic or financial, I'm making the assumption, I'm not sure it's accurate, but that most of you are probably working for a potential strategic buyer. I believe I saw from the list there's at least one financial on the call, or that was reserved or RSVP'd. The financial, in our experience, and I'm sure this is just our bias from looking at it from the outside, is more focused on the financial statements, the numbers, because the key to the acquisition is often, does this yield a return based on the purchase price we're paying now versus what we're going to get in the future when we resell it? Whereas strategic, that's important, but there's also more of a concern about other matters like fit within the overall organization, issues, like I said, about cannibalization, how does the culture fit? Are these people going to do well working with our people? What are relationships like, et cetera? So a little bit more to think about on the strategic side, although you may or may not have specific diligence questions. It may be more of a, how do we feel about the transaction after we've done a bunch of diligence and spent a lot of time with the sellers. Other factors that can affect it, public versus private. If you're a public company, as you painfully are aware, the deal may be reportable if it's material to you. It may require a stockholder vote on your side, which will most likely require a meeting and a proxy process. And then you also need to be concerned about the state of the financials of the seller and whether they can be easily incorporated into yours. So more complications if you're a public buyer. Industry, of course, the level of diligence may get more intense if it's a regulated industry. And then not to forget, the risk tolerance of the buyer. So you and your superiors, if you're working on the deal, how much risk do you want to take? How much do you and they want to put kind of your names and careers on the line as you give a report back on what may or may not be wrong with the entity? So Jessica.
So then thinking more about the big picture and factors that can affect diligence, some diligence might actually be required, prior to entering into the LOI, certainly, and in connection with the preparation of the LOI to figure out the appropriate structure of the transaction. So what do we mean when we say structure? Well, basically, as M&A lawyers, when we think about structure, we think about two buckets. We think about either an asset deal, the buyer is acquiring the assets of the target and predominantly leaving behind the liabilities, or we think of an equity purchase, so buying the ownership interests of that entity, be it stock or LLC interest, partnership interests, or doing a merger. So, as a general matter, buyers prefer asset deals because, again, it reduces their exposure to existing pre-closing liabilities. It allows the buyer to take, a step up in basis on the assets, which, from a buyer's perspective is great. It allows for more depreciation. It puts the buyer in a better tax position. But it as a general matter, also requires more third-party consents, because if you think about, the contracts that you all draft on a regular basis, a lot more contracts say that they require consent to assignment, which is triggered by an asset deal, because you have, one entity and you are assigning the contracts, from the existing target to the buyer, versus in an equity deal where there's just a change in ownership, you're just triggering generally a change of control provision. Much less contracts generally have those. You think leases, you think, debt documents, those types of contracts, but not your general customer contracts. So, typically at the LOI stage, you're not digging into diligence at a very detailed level. But if you know, for example, that the target has 1,000 customer contracts and they're all on the same form, and that form has a change of, anti-assignment provision, you're probably not going to be doing an asset deal, because there's just no way you're going to want to go out and get all of those consents. So those are the types of issues, that we think about early on in the deal. We also, again, on the step up in basis, just as an aside, if you can get a step up in basis in an equity deal as well, if you're purchasing an S Corp, subchapter S corporation, we can do what's called an F reorganization, which is a structure that allows for the deal to be treated as an asset deal for tax purposes. There's also something called like a 338H10 or a 336E election. Those allow for it as well. Or if you're buying an LLC, that will actually treat the deal for tax purposes as an asset deal. So it's still an equity deal for corporate purposes, but an asset deal for tax purposes. So that is another way to sort of get the buyer that benefit without having to do a pure asset deal. We also think about big picture. What's the consideration being paid? Is it 100% cash? Okay, well, that's fully taxable. That's a little bit simpler. Maybe it's stock. Maybe it's a combination of the two. If you do have a financial buyer, sometimes the seller is what's called rolling equity, meaning the seller is actually converting some of their equity into the buyer entity. So, as you might imagine, those bring up a whole host of issues. If you're the seller, they're going to have concerns around the liquidity of that stock. When can they sell and get paid? Do they have, what's the tax treatment of that stock? What kind of protections will they have as a minority investor, which, as the buyer is also a concern to you. So those are some of the things you need to think through with your internal clients. And then the other structuring concern that, greatly impacts what we do is whether you have what's called a simultaneous versus a subsequent sign and close. So, when Paul and I both started our careers, almost every deal was a subsequent sign and close. So that's where you sign the purchase agreement, and then you have a period of time where the parties go out and meet the various closing conditions, getting those third-party consents or, regulatory consents, sometimes obtaining financing. And shareholder meeting. Versus a simultaneous sign and close where you actually sign the purchase agreement and title and money, the consideration change hands on the same day. So there's different reasons that might push you towards a subsequent sign and close. These days everyone tends to prefer simultaneous, but if you do have regulatory consents, for example, if there's antitrust concerns, if you're doing a large transaction, north of $100 million, you might need approval from the Department of Justice, HSR consents, and filings. And so that would push you towards a subsequent sign and close, because oftentimes there's going to be seller sensitivity around, putting the deal out in the public before you have a signed purchase agreement.
Yep. Thank you. So, and all of that, by the way, on the prior slide, I'll go back for a second. We said a bit more on big picture there. And the reason was because many of these things really are the very early stages of the deal, if not in the LOI itself. No, I wouldn't say that all LOIs we look at have these topics addressed, but I think a better LOI would. It does require some upfront diligence to figure these out, though. So that's kind of the initial stages, getting your arms around the transaction, what it's going to look like. So kind of backing up, I guess, a little bit, why does the buyer do due diligence at all? Two functions. The buyer is paying, of course, and wants to know about the imperfections and risks in the business. They want to know they're getting the benefit of the bargain. Is this company worth what we're paying? And you think about it for a second, we had to back up to that level of 30,000, 50,000 feet, because if we're on the buy side, which is what this presentation is about, like nearly any problem can affect the value of that business. And so on the buy side, the diligence burden is greater, I believe, than on the sell side, because as the attorney, whether you're acting in your role as an in-house attorney or if you're outside and working in that capacity, it's your job really to figure out any legal issue with the deal. So you are really responsible for turning over all the rocks and thinking about it and thinking about, does that rock over there need to be turned over? And yes, thinking proactively about what could go wrong and what could affect the benefit of the bargain. So there's a lot of responsibility there. In private deals, you also have the added function there regarding price, that there's typically indemnity, which means if the seller fails to disclose to the representations, that would create an indemnity claim. In other words, the representation would be inaccurate. You ask you and your outside attorney, or maybe if you drafted the agreement, just you ask for representation, it turns out to be incorrect, meaning that it's wrong. The seller agreed to make that representation. They didn't provide anything in the disclosure schedule to say it was incorrect. Well, now you have an indemnity claim. So that's a function of diligence kind of in the broad scope. There is a difference between the diligence at kind of what I would call the diligence level and also in the representations level, which is a kind of a separate part of diligence in my mind. We'll talk about that difference in a bit, but it does create an indemnity claim if you get to that point and the seller has misrepresented. We've got a little item here, sandbagging. I don't know that we want to dive into that here on this call, but typically I see in agreements that the buyer has the right to make an indemnity claim, even if it knows that the representation was untrue. Many of our sell side clients initially, when they hear that, react with righteous indignation, don't believe that's appropriate. But I would say in the majority of deals, it is in there that either the deal is silent and the deal is under Delaware law where you get sandbagging as a matter of law, or there's a proactive pro sandbagging clause. And just because you start from the fact that the seller is misrepresented. So again, not want to dive into too much detail, but you do have an indemnity claim. And then lastly, just on that purchase price point, again, what I said before, anything that would reduce the attractiveness of the business at the expected price. Meaning, you may find something in your analysis that merits a price decrease, and sometimes a significant one. There's some political capital to be paid by asking for a price decrease, so it tends to be bigger stuff as opposed to smaller stuff. But that's something that you may be asked to figure out as part of your job. And then integration is also an important function of the diligence. It's going to provide you and your business clients information about how the business is operated so that the business can be folded in post-closing. So what's the process? Well, first, like we talked about before, there's kind of a 30 to 50,000 foot level. Get a broad sense of what needs to be reviewed. This may also dictate who's on your team, meaning you may need to pull in addition to lawyers within your group, do you need to involve inside versus outside counsel? Do you need to involve regulatory counsel? I've got a note here, clean room, meaning some information about the seller may be so sensitive, maybe from an antitrust standpoint, maybe because it's trade secrets that the seller just doesn't want to share with you. Maybe there's a super sensitive contract with a party that maybe you are in litigation with as the buyer. There's some sensitivity to providing you full access to everything. And there may need to be some information, according to the seller's point of view, that needs to go into, quote, clean room or a subpart of the data room that only certain parties are accessing. So that may come up in the early stages of this as well. I mentioned before, there's a question about who's doing what, inside versus outside counsel. You may be in your capacity as in-house counsel also coordinating the comments from the financial department, the accounting department, tax, legal, and regulatory. All of that stuff is it very well may flow through you, depending on how your organization is set up. Now, you may have your own, or your outside lawyer will have a legal diligence checklist, but other members of the team may have their specific diligence requests as well that you may get asked to be the quarterback on. So you may be asked to assemble the diligence checklist. I saw a draft that Latham & Watkins put together a number of years ago. Is intended to be all-encompassing. It was over 20 pages long in relatively small font. And again, it was intended to capture all industries, all situations, and nothing ever really works completely to do that. But just by way of example, a 20-page diligence checklist is now out of the realm of possibility. You see lists that approach that size. And then there may be subparts, and then there's also follow-ups we'll talk about in a minute as well. But it also may fall to you to set expectations with the other side. In other words, what's the timing? If your business people are saying this deal needs to close by the end of this month or the end of next month, you may understand that, okay, we need to have the diligence request list responded to with the majority of the requests fulfilled by, like, say, end of this week, end of next week. And it can be a long process for sellers, particularly if they're smaller organizations, disorganized organizations, to get their stuff to you. And then also you need to set expectations with members of your team to when to feed you their comments so that you can incorporate them and respond. And lastly, on this slide, what is the work product that either your other folks that are working for or with you, or that you are going to be asked to deliver to either your superiors or the business people? Is that going to be a full-blown diligence report? Is it going to be a memo? Is all you need an email from outside counsel about what the issues are? We have some clients that come to us and say, hey, look, I just want a kind of a red light, green light, yellow light list of what's critical and what's not, because they're moving fast enough. They don't want to spend the time, nor do they want to pay us to create, a 30 to 50 page memo of everything we reviewed and what our responses are. So you kind of, in your position on the buy side, may be very well asked to say, hey, what do you want? Do you want that full-blown memo, or do you want it to be something less than that?
And then one, just aside to that point on process, something that can help sometimes to push things along a little bit quicker if you're not getting the responses you'd like to see on those diligence requests, you can set up what's called a diligence call, and you can have, the various subject matter experts kind of cover their areas. And that's a way sometimes to just sort of figure out what you really need to know, because, like Paul mentioned, some of these smaller sellers, oftentimes they're disorganized. They might only have 2 people working on a deal. They just can't be producing the types of diligence requests that you're looking for. So having those calls can be helpful to really understand what the lay of the land is and figure out where you need to focus your efforts, especially if you're on a tight timeline.
It also helps establish the cadence, right? Like if you have that call and everyone's on the call and you say, we're going to talk in a week on where everybody is, then everyone will get the message, oh wait, I need to have accomplished my tasks within the next week or the next 3 days. It helps them kind of feel the drumbeat of how fast you need to go.
Absolutely. Okay, so now digging in a little bit to the nitty gritty, Paul mentioned those rocks. So what are those rocks that we think of that we need to overturn? Starting with two of the big ones. So tax and capitalization. I don't think most of you are probably the ones doing the tax diligence. It might be being handled by your tax department or your, inside or outside CPAs, your accounting departments, but it is pretty critical. Obviously, in addition to just normal tax diligence, meaning, someone taking a look at the returns and, getting comfortable with them, that, the people preparing them knew what they were doing and been complying with the various tax laws. Certain types of issues that we've seen, crop up more recently are, kind of hot button issues. Failure to pay sales taxes has been a really big one in the last few years, depending on the industry that the seller is in. Software companies come to mind that they didn't previously think they necessarily had sales tax obligations in certain states, but depending on how they've structured their business, they might have. So that can be a large source of liability if they haven't been paying those taxes. Employee retention credits, I don't know about you, I get emails daily almost, someone asking me if I need help claiming these retention credits. So sellers have been claiming these, and the sellers often expect to be getting the reimbursement for that themselves, the return, even if, the closing is going to have already happened. And so that's something that needs to be thought through, and making sure that those retention credits were properly applied for if you as the buyer are going to be giving them the credit for that. Paul and I in our practice deal with a lot of subchapter S corporations, as we mentioned, both on the target side and on the client side when we're representing sellers. So, a subchapter S corporation is a pass-through entity similar to an LLC, but it is very easy, unfortunately, to actually blow that S election, meaning to take an action that compromises that election. And if you're the buyer and that election's been compromised, the result is that you're not buying an S corporation, you're buying a C corporation that hasn't paid its proper taxes for the last however many years since that election was blown. So it's really critical diligence. So the types of issues that can blow that S election, an S corporation cannot have any foreign shareholders. It cannot have any entity shareholders as a general matter. There is a small exception for single member LLCs. There should be a single class of stock. There's an exception to that, like you can have voting versus non-voting stock in your charter, but you can't have different economic rights among classes of stock. So if you think of like preferred stock versus common stock, that's a no-no. And one thing, sort of subcategory of that single class of stock is the sellers need to have been making pro rata distributions in accordance with the stock ownership. Because if they weren't doing that, that can indicate that there was in fact a second class of stock. And then actually the biggest issue that we see, and it's sadly one that many CPAs do not know about, which is why we see the issue so often, it can be fixed, is that if any of the individual shareholders reside in a community property state, like California, the spouse of that shareholder actually had to sign the S-election form 2553 when it was filed. And I'm gonna go with 8 times out of 10 that has not happened. So our tax guys spend a lot of time cleaning that up and making a correction for that. And then capitalization, tying out the cap table is, whether you're doing an asset deal or a stock deal, one of the single most important items of diligence, it's one of the first ones that should take place. It is oftentimes one of the ones we see the most issues unless we're dealing with public corporation targets. So, what does that mean, tying out the cap table? What do you have to do? So, you need to look at the cap table that the target is prepared, so who they think the owners are. And then you need to figure out how each of those owners got on there and did they properly acquire their stock or LLC interests. So when you're looking at original issuances, issuances by the target to the shareholder, you need to see, think back to corporations. You need to see a board consent approving that issuance. You need to see, a purchase agreement or a grant agreement signed by both parties for that issuance. You need to see payment for the stock unless it was received in connection for services performed. Hopefully a securities exemption was filed with the relevant states where the shareholder resides. That often doesn't happen. Hopefully there's stock certificates if it's a certificated entity. And you can actually track those, along history to make sure that they tie out. One helpful way, because again, we see a lot of issues in this area. I actually am selling a company right now where they told us there's one shareholder and yet there's 6 stock certificates for individuals, but they're 20 years old. And there's no documents to back up that any of those shares were sold. So you can go back and you can check the K1s, which are, the Schedule K1 attached to the tax returns for pass-through entities. And hopefully, what the target is telling you about their share ownership over time ties out against those tax returns for the various years. So luckily in our case, there's only one person on the tax returns for the last 20 years, which is a helpful fact, although, not a cure-all. And then when you think about stock transfers or equity transfers, you want to make sure that you see, assignments from the former shareholder to the current shareholder, again, tracking against, those stock certificates, purchase agreements between the individuals. And if the company was actually buying shares of its own stock, back from individuals, you want to see redemption agreements. Options are one of the unfortunately biggest issues we see, and it's probably one of the hardest and most expensive to clean up. But again, when you think of the types of diligence you want to do, you want to look at the option plans, the equity incentive plan, make sure it was approved by both the board and the shareholder. You want to see grant notices to every single optionee, signed by, again, both the company and the optionee. Hopefully evaluation, a 409A evaluation was done, or the board at least established fair market value for each option grant. And you want to see signed documents. It is not okay if those grant notices aren't signed, or if those board and shareholder consents aren't signed. You can have invalid options, and that can be a large issue that needs to be addressed.
Can you just help me understand, just to back up a step? It always helps me to back up. But if you find a problem in capitalization, what's the issue? I mean, now I found, okay, this looks like someone's claiming that they own stock, or we think there may be someone who's never bought out. What does that mean for me as a buyer?
Well, so as a buyer, right, you're going to have a whole host of representations from the seller that they, that this is their cap table, right? And they're gonna stand behind that, and that's gonna be what's called a fundamental rep, right? It's so critical to the benefit of your bargain for what you're paying for that company that they own it. But if, let's say you're doing an equity deal and the cap table says there's 10 shareholders, all 10 of those individuals are gonna sign on to that agreement. But to Paul's point, what if there's one other person who's not signing on? Well, the question becomes, have you actually bought the entire corporation? Is there someone out there who has a claim against you as the buyer, against the seller for ownership rights? And so it is truly critical to figure this out. You can, as we've talked about, you can get indemnification protection, but you really have to analyze that issue, either in-house or with your outside counsel to determine if it's something you can get comfortable with. And this again, like kind of bringing us back to the beginning a little bit, this is where sometimes alternative structures can come into play. A merger is something you might consider in that instance because you don't need all of the shareholders to sign on. But it's something that you have to, it can truly be critical to whether or not you own the company and you're getting the proper approvals from everyone involved.
Yep. All right, next slide. More key legal issues, title assets. Does this company who's selling you the Brooklyn Bridge actually own the Brooklyn Bridge? Or is there a lien on it? Is there a bank line? And you can do lien and litigation searches, kind of word of the wise. They can get expensive if you go down to like the county level, if you get a seller of any size in multiple counties. If you just ask your law firm, hey, do a search everywhere, it can get expensive. And it's not because us, the outside law firm, is charging you. It's the service provider that we've hired that's going to be charging you for each individual county. So you kind of have to think about, okay, where would it be that I would care and focus in on those jurisdictions. Just security interest generally. Again, you want to make sure that you are going to own the assets when the deal is done, whether it's a stock deal or an asset deal. There can be also prepayment penalties on bank lines. We see that not infrequently. So about a bank line, someone's done the diligence, identified it's there, and you're planning on paying it off. The seller says that's $1 million line of credit, and we've got $1 million outstanding. Okay, we're going to pay $1 million, but oh no, wait, it says you got $100,000 prepayment penalty on that. So that's something that you would only discover upon reading the contract. So you need to read the contract. Other titled assets, last one is contingent obligations. In other words, there can be guarantees. It's not unusual, frankly. I've got a client that's a smallish organization that's selling a company right now, and it was principally owned by one founder in the somewhere between 50 to 70% level, as I recall. And he actually had, quote unquote, his corporation guarantee the loan that he used to buy the real estate where the company is operating out of. So buyer doesn't want to own the real estate. There's going to be a lease, but it doesn't want the guarantee either. As a new owner, it doesn't want to have guaranteed this other now unaffiliated individual's mortgage. So that's stuff that you will find, again, only upon reading the documents. Contractual issues, consents, Jessica mentioned before. Not unusual to find anti-assignment provisions, which may or may not be triggered depending on the type of structure, change of control. There are some jurisdictions that have made noises about treating a change of control the same way about assignment. In our mind, typically, we would assume that if there's a contract that has an anti-assignment provision, but you are doing a change of control, in other words, buying stock, that does not trigger an anti-assignment provision, but the law is not uniform there. So you may need to check the governing law of the contract. Which itself may be ambiguous. So lots of stuff to think about. Permits and licenses. I mentioned here, I put on here, I did some work for Qualcomm many years ago. So if any of you are at Qualcomm, none of this is inside or confidential information, but there were features in Qualcomm's contracts that actually would have made it difficult to be acquired. And I won't go into detail about what they were, but you can think about, there can be provisions in contracts that you walk into as a buyer where you will say, no, that's not going to work for us, the way that contract is worded. Whether it's rights to something or maybe it blows a permit that you've got to work with somebody, or it may be something that's not really legal in nature, but are you going to be working with an entity, is the seller working with an entity that you don't want to be working with as a buyer? And then rights of first refusal, privacy policies, other transfer restrictions, those you can read the contract and find, oh, wait, there's an issue here that they can't sell the business to anybody else without talking to them, this counterparty to a contract. And that's something that obviously can put the kibosh on your deal pretty quickly. There are also non-competes, most favored nation clauses, exclusive arrangements that you'll want to have discovered. Term and termination, this is one that comes up not infrequently. You know, if it's an increasing rent environment for real estate, like kind of is now, well, if the lease expires next month, are you going to have to renegotiate the lease at a higher cost? Are there key contracts? I had a client come to me recently and said they want to do a deal with Amazon where they were going to get a couple $1 million in revenue, and in the back of their mind, they're thinking when they sell at a 4x multiple, this is an $8 million addition to their value. But the problem is the contract with Amazon says it's terminable at will. So that $8 million that my sell side client is thinking is going to be added to their sale price, if the buyer does his diligence, they'll discover, well, they probably need to discount that because Amazon can walk away at any time. And then indemnification, not unusual for a selling entity to just agree to indemnify somebody for something that's probably broader than they should have because they didn't want to pay to have an attorney take a look at it. And so you'll look at it as a sophisticated attorney and decide, oh my, I don't want my client on the hook for that level of indemnification. It's something I would have never agreed to in their shoes.
So continuing on our key legal issues and all of those rocks to uncover, past acquisitions. So if the target has acquired, either the assets or the equity of other entities, you really want to dig into those deal documents, one, to make sure that they were covered, from an exposure standpoint, and that you're not inheriting sort of additional exposure that you wouldn't have agreed to. And two, to see if there's ongoing obligations, right? Was there an earnout payable in that deal that hasn't been paid off yet? Typically in these deals, that's picked up in the definition of debt and comes off the top of the purchase price, but you need to know it exists to make sure it gets paid. Paul just mentioned indemnification obligations in sort of your commercial contracts, but those obviously also exist in purchase agreements, even for the buyer. You want to look if there's funds sitting in escrow when those get released, those types of issues. Being in California, employment issues is probably, one of the single largest areas that our buyers focus on. You want to get employment attorneys involved if at all possible. So the types of issues that they're looking for, typically, misclassification is probably one of the biggest ones. You think those wage and hour class actions, where individuals categorized as exempt, meaning exempt from overtime, versus non-exempt. If they should have been receiving overtime and clocking in and out and haven't been getting all their meal and rest periods, that can be major exposure. Were individuals categorized as contractors when they should have been employees? Now, obviously, we're all, familiar with the, recent changes in this AB5, but it is an ongoing issue. Many, many corporations are not in compliance with this, and we see this pretty much on a daily basis in the course of our work. Privacy concerns is a really large, area. The CCPA in California, GDPR internationally. This feeds in on the employment side, but also, just generally on the customer side as well, and privacy issues. But, sharing of your employees' information, it is standard in diligence for buyers to request, employee information, right? Names, start dates, titles. You do have to be careful as a buyer, and it's a concern for the seller, but it's also a concern for you as the buyer that you're not requesting or getting, personally identifiable information of these employees, because even though maybe it's the seller who violated the law and handing it over, like let's say they give you everyone's social security number, you might still have to be dealing with a claim then of very disgruntled employees post-closing. So you want to be careful about that. I-9 and, legality issues, obviously depending on the industry, I represent a lot of clients in the janitorial services space. The right to work and be legally present in this country is an issue in those deals. And so, I-9 diligence is actually somewhere where we bring in a specialist, and our client brings in a specialist to assess that and what the exposure is there. Employee handbook review. Hopefully the target has an employee handbook as a starting point. You want to take a look at that, because that's where all their policies are typically. And oftentimes the target's going to tell you, well, it was prepared by ADP or a similar organization. It's fine. I know it's in compliance with the law. that's not always the case, because unfortunately, those larger organizations don't always actually stay up on every development. If they're national organizations, they might not be as focused on California, and California has a lot of specific changes. So we typically have, our employment attorneys look at those in detail, and if there's employees in other states, we have specialists in those other states kind of dig into those if there's a concern. Related party transactions is a big one. Paul kind of alluded to lease issues, but if the seller actually owns the building that it is using, and you, the buyer, are now going to, be stepping into their shoes, you need to take a look at that lease and make sure it's actually on an arm's length basis. It probably isn't. So that might be something you need to look at renegotiating in connection with the deal. And that can actually get pretty contentious, which is interesting when you think it's usually sort of the tail wagging the dog a bit, but it does happen. Or if there's a key supplier and it turns out that is owned by the seller's sister-in-law, again, might not be on an arm's length basis, and that might be a contract that you need to really dig into and think about, potentially renegotiating in connection with the closing. Qualification to do business. This is an area we do see a lot of problems. This luckily is one that's usually pretty easily fixable, but what this relates to is if, the target has leased premises, certainly owned premises, or employees. Most states, in other states, most states require you as a foreign corporation or foreign LLC to qualify with the Secretary of State of that state. It's a pretty easy filing. It just doesn't get made very often. So oftentimes, especially in our remote work environment that we're in, a lot of companies have, one individual in Montana. Well, they probably need to be qualified to do business in Montana. So that's something that you need to figure out in diligence, and they probably need to clean up in connection with the closing.
Short slide, a couple more legal issues. Regulatory, we talked about that a little bit before. Industry specific, we represented a number of years ago a company, again on the sell side. They said they were in the green space, but what they were a catalytic converter company that if you were to walk by their facility, had a lot of old car parts laying around, and they were grinding them up to take out the rhodium, the palladium, and the platinum out of the catalytic converters. And of course, there were environmental concerns. And so the buyer in that instance had environmental counsel digging in. They did a review of the real properties to make sure there weren't any issues, that notwithstanding they weren't buying the real property, that they were going to be held responsible for later. That's just an example. Banking is another one where there's going to be industry specific regulatory issues, lots of them. Jessica mentioned a couple of other, you've got privacy issues that are kind of encroaching on a number of companies' practices where they may not have been terribly regulated before. So those issues, depending on the industry, you may want to have specialists come in and assist, or you may have someone in-house that focuses on that, and you need to make them part of the team. Government contracts is another area where those of you who are involved in the government contracts, in a government contracting entity, painfully a whole set of regulations, or 2 or 3, that are going to be governing what happens. One quick heads up, if you're not in the government contracts arena and you're buying a company that does have government contracts, typically intellectual property that's developed on the government's nickel cannot be, the government gets a license to that IP, which means that if you want to charge them for use of that IP, it can be problematic. So just as a heads up, that's one of many issues. And then government contracts also, and this is, again, I'm sure there's exceptions to this, but government contracts typically are also subject to novation, meaning they're not assignable in the same sense that a regular contract would be. Every contract essentially has a built-in anti-assignment clause with a government contract. So again, there probably are exceptions to that, but be aware of that as a potential issue if you're buying a company that has a lot of government contracts. Litigation, not surprisingly, if you want to know what litigation is out there, so that's got to be on your due diligence checklist. Tell me about what litigation you've got ongoing, what's been settled, and you want to know what the status is if something hasn't been settled, and what's the level of exposure. And on that point, what's the level of exposure? Well, there you're going to have a frank conversation with the other side about, okay, what exactly happened and where do they think they're at fault? Now, they may not be willing to tell you that because that's privileged information, right? And you may or may not be viewed as being on the same side as them when you're doing diligence in an adverse transaction. So A solution to that, it doesn't always work, I don't think, but a solution is to enter into a common interest agreement, which is an agreement where both sides say, okay, for this purpose, we are all on the same side. And therefore, when I, seller, share information with you, buyer, we're under this common interest agreement that preserves the privilege. So they can give you all the information you want to know about where the exposure really is, and you can make a prudent decision about how much exposure there is before you close the deal. So I'm going to stick with this slide. Jessica's going to jump in on the next one. I wanted to talk a little bit again about the interplay of the representations and the diligences. So what we've been talking about mostly so far is the diligence effort. And in my mind, what that means is you and your outside law firm and members of your team are all holed up in your offices, reviewing contracts, talking about issues you're finding, raising issues, figuring out, do we need to have a change the structure? Is the purchase price appropriate, et cetera, kind of getting your arms around everything that is this entity. That's what I would call the diligence process. So why then are there representations in addition to that diligence? And this is a quote we hear from many sellers when they are asked to make representations and then to create a disclosure schedule off of those representations. I already told you that. I already told the buyer that. Why? They asked me 12 questions about this in diligence. Why is there a representation on this? Why are they asking for more information? Now, one reason, a practical reason may be, well, because there may be outside attorneys that weren't involved in the diligence process that are drafting the reps, right? And they want to do their job right and get a rep on every topic that's relevant, and therefore also get all the disclosure that's relevant. Okay, that's one reason. But also on the buy side, you want to make sure that, you know, all that you've been told, you asked for a load of documents, you got it, you reviewed it, you spent a lot of time and money reviewing it. How reliable is it? Can you sue them for giving you false information? And the answer is generally no. I mean, unless it's outright fraud, which is difficult to prove, the answer is there is no remedy for them providing you an inaccurate document. So why do you need a rep? Well, you need a rep that says, you gave me, seller, an accurate copy of all your contracts. And that's one of the many representations in the definitive agreements. So now you've gotten that in writing, that you know you can rely on what they provided you in diligence. And so all that effort doesn't go to waste. And it does restate many of the things you've asked for in diligence, but now with, if it's a private transaction, an indemnity claim if the representation is inaccurate. Now I've added a caveat there. I have some buy-side clients come to me and say, okay, well, we found this problem in diligence, but we've got a rep on that point, right? So there's an indemnity claim. Well, yeah, that's true, but I like to use the analogy that indemnity claims are first aid. And the diligence helps you avoid the injury in the first place. I would typically say, and this is not 100% the case, but typically I would say you'd rather avoid the problem than try and put a Band-Aid on it later. And that's why I use the first aid example. You don't know how deep that cut is, to extend the analogy, right? It may be significant, there may be an infection, push the metaphor as far as you want. It's really only the initial kind of reparatory stages of it to get an indemnity claim. If it's a fundamental issue, you would much rather know and maybe call the deal off or adjust the purchase price up front than try and rely on an indemnity claim after the fact. And why is that the case? Because indemnity claims are typically limited in some way or another, whether it's in dollar caps, there may be baskets that apply. You have to have a claim of over a certain size before you can make any claims against the seller. Some claims, they're hard to make. Sometimes now for a financial buyer, if you're paying a multiple of earnings, you're paying a 5x EBITDA number, and now you've got a problem that's a $100,000 license. Well, again, go back to my other client's example, a $2 million Amazon contract, and you're giving a 5x multiple. Well, that's $10 million of purchase price, right? That you would have taken off the top if you had known about this issue. And therefore, an indemnity claim, are you going to make a $10 million indemnity claim? Well, you can. Are you going to get it? Well, who knows? They're going to fight you tooth and nail. So better to know it up front. Do the diligence first. But that's the overall, like, why do we do reps and diligence? They both serve an important purpose. So diligence helps identify the appropriate reps in part as well. Your outside counsel or you will probably have a base set of representations that you use in agreements, but the diligence may highlight the need for something more. Like, if you've identified a privacy issue, you may need a detailed privacy rep. You may need to see copies of documents on that point, or copies of documents related to litigation where you may have had just a short rep that says, oh, there's no ongoing litigation. Well, you find out there is, or you find out there is in diligence. Maybe now you need more of a robust rep saying, okay, you've provided us copies of all the complaints and they were true and accurate, et cetera, et cetera. So there's an interplay here. Diligence also helps to identify who the knowledge parties are for the reps. You know, the seller will ask for a number of the representations to be knowledge qualified. I didn't know I was violating the law. Well, what does knowledge mean when you're talking about a company? You really have to settle in on, okay, whose knowledge counts for that purpose? And there's probably a team of people you've been dealing with, and you will want those key people that are overseeing the transaction to be on that list of whose knowledge counts for knowing a represent true. And then the diligence also will help you identify what we call standalone indemnities or special indemnities. You know, if you find there's employment issues, or like I said before, litigation, or failure to comply with the law, failure to pay and report taxes, you may want to just say that there's a special indemnity for that. And what I mean by special indemnity is indemnity under the representation is the one that typically has some sort of basket, a minimum claim size, or minimum aggregate damage amount before you can make a claim. Standalone and special indemnities do not. So if you have $10,000 that's owed on a standalone indemnity, you're typically allowed to get your $10,000 back without going through all the other rigmarole of show me where there's a breach of rep and show me how you've gone over the basket. And these standalone and special indemnities are on the more sensitive issues that you've identified in diligence.
Okay, so we've talked a lot about the legal issues in diligence. As Paul mentioned at the beginning of this chat, you know, there's other types of diligence going on, including obviously on the business side. And so these are the types of issues that, you know, you're working with your internal clients on and that they're thinking about, and they're going to be asking you to weigh in on as well, while you of course are handling, you know, everything on the legal side. So, you know, confirming full disclosure. You know, we've talked about why complete disclosure is so important. But that is something they're really going to want to know to make sure that they have the full picture of this business they're buying. You know, identifying risks, as we've talked about, you know, kind of in detail, but on the business side too, not just on the legal side, but what are, you know, are these sort of, you know, is this recurring revenue on these customer contracts? Paul mentioned, you know, is there an issue? Maybe does the seller have a relationship with a competitor? You know, what are these larger risks just from the business itself? And then what are the synergies, of course, you know, how can they save money? How can we have a great combined effort going forward? You might be helping them identify key employees. You know, they might be thinking about entering into employment contracts with these individuals or other ways to retain these individuals. Who are the key customers that, you know, we need to ensure stick around for the long haul. Planning integration is a big one. You know, thinking about that culture fit. Think, you know, particularly in terms of employees and just, you know, generally the various divisions or the various, you know, groups within the organization. What is that going to look like at the end of the day? You know, are you going to have 2 accounting teams, or are you going to have 2 HR directors? You know, who's working under whom? How are you integrating these people into your organization to ensure that, you know, the overall venture has success going forward?
Benefits plans too.
Benefits plans is a big one. You know, typically benefits plans at the seller terminate at closing, if you think of like the 401k plan or any kind of retirement plans. But, you know, if I'm the seller, I want to ensure that my, you know, employees have good benefits going forward. And so they might, you know, actually be doing a little bit of diligence on you as well to kind of identify what types of things you have in place to help, you know, protect their individuals. Financial terms, you know, of course, you know, the purchase price, the value, purchase price adjustments, you know, net working capital is a big thing we worry about in these transactions, you know, making sure on the day you close, there's sufficient capital to operate the business you just acquired. You know, when you think of current assets over current liabilities, so thinking about earnouts, you know, earnouts are a way to bridge the gap in valuation between a buyer and a seller. So, you know, I, the seller, think this business is worth $20 million. You, the buyer, think it's worth about 15. Well, maybe we have a $5 million earnout so that, you know, the seller can truly prove to you when it hits these metrics that, you know, the business is worth what they thought it was worth. And then taxes, you know, always taxes are a big one. Capital needs, you know, I mentioned the net working capital adjustment, but, you know, maybe there's a line of credit that the seller has historically relied on. That might not be, you know, most banks aren't assigning letters of credit over to new buyers. And so, you know, that's something to think through. Just, you know, do you have sufficient capital as the buyer to be funding into this business at the level it's going to require, and depending on what your plans are for the business. Usually you're not buying a business just to kind of keep it at the same level. There's probably growth planned. And so what is that going to require and what is that going to need? Talked a bit about the hiring and transfer of employees. This can get very sensitive. Deals are often not, if it's a simultaneous sign and close, deals are not often announced to the employees until the day of closing, maybe a day or two prior. If you're doing an asset deal, sometimes a little bit sooner so you can actually transition those employees, but that can be a very tense process. And if it is not handled correctly, it can cause major issues. If you have, a bunch of employees that have just found out that they have a new employer that they did not agree to work for. And so that is somewhere where, HR should be brought in earlier than later on these deals to help you think through those issues internally and how you're going to handle that process and that communication with those employees. Because presumably if you're buying this company, you need their people. And then deal breakers. Unfortunately, deal breakers is something we talk about more than we would like, but identifying with your team what those are, what are issues you just cannot get past as the buyer, and recognizing earlier than later when they start to come up, right? So that you're not continuing to spend time and money on something that isn't going to go anywhere. So it's difficult, but having those frank conversations is important because you'd rather bring it up sooner than later versus have someone, say to you 2 months down the road, or God forbid after closing, why didn't you mention this? Did you know this was going to be an issue?
All right, follow-up requests. Now, when are you done? There's a lot of work, as hopefully this has been clear. If you've been through it, there's a lot of work here, and you've done an awful lot of work, and you're trying to figure out what's an issue and what's not. As you discover issues in the process of doing diligence, you may need to send follow-up diligence requests. So you provided this 20-page long initial request, and now you got to provide another 2-page long supplemental request saying, hey, we need more information about this litigation you told us about. We need to talk to the attorney that's handling the litigation. We need to have a call. Sometimes there's a follow-up to the follow-up, and a follow-up to the follow-up to follow-up. The question is, when do you stop digging? I think it's a rational question because if you keep digging, you will probably keep finding stuff. So when's the right moment to stop? It may depend on your company's risk sensitivity. If you bought another company last year and it turned out to be a disaster, and that management is going to have an allergic reaction to any sort of problem, you're probably going to be digging a little deeper. If you're being told we got to close next week, or we're not going to, this deal needs to be announced at a trade show, or we know that it's accretive to us and we want the revenues to be reported with ours by a certain date, timing sensitivities may make you stop sooner, maybe even sooner than you'd like. Another issue is how close to the line are you on deal price? Financial buyers, like I said, it's a little bit more sensitivity, at least in my experience. Because if they're looking at, hey, I want to buy for X and sell for Y, and I got a multiple I got to make in between, they're applying a multiple to very small variations in earnings, which can have a big impact. Time you just talked about before, I tend to start feeling comfortable when I start seeing the same information over and over again. In other words, if the story that they're telling me sounds rational, and the outside facts that I'm getting are doing nothing but confirming that to me, in other words, there's nothing new that I'm seeing that contradicts what I'm being told, I start to get a general feeling like, okay, I'm not finding anything new here. If I found something I hadn't been told before, then I'd want to keep digging. But once it kind of starts to all settle in and you're getting the same answers to the same questions, then I start feeling like, okay, either they're totally committing fraud and my radar isn't up enough, or it's all good and we can start slowing down. Or when you request additional information, it only raises minor issues. There may be other signs, but there is a point at which you will want to stop. There is a point at which the seller is going to be wishing with their whole heart that you are stopping because they've been responding to difficult requests for a long time. So that's just kind of a spidey sense on when to stop the request. So that was our presentation. We may have a minute or two. We have literally 2 minutes. If anybody wants to ask a question, I guess go off mute and I don't think we have access to the chat, so sorry on that.
Yeah, I'm checking the chat and I don't have anything yet, but I will let you know if something pops in. Giving others a chance. I was just wondering, I guess I'll ask then, what's going on in M&A lately? I know it kind of cooled off during the recession. Is it heating back up? Is it sort of still crawling along, or do you have any observations you can share?
Yeah, from my personal observation and what I've observed around here, things have been up and down. Like there have been slow parts of the year. There have been parts of the year where things have sped back up. I get the feeling that the fourth quarter will be a little bit more busy than second or third quarter were. So I keep having the sense that people are kind of getting their arms around the increased interest rates and understanding what that means for them and what that means for deals. And therefore, buyers have been willing to proceed. You know, the Fed recently announced again, thinking about raising rates, so that kind of puts a little bit of a monkey wrench into that. But I think by and large, organizations are getting a sense of what the economy is like, and they can't sit around forever, particularly the financial buyers who have a lot of money in reserve. They can't sit on that money forever. They have to give it back. So we expect the financial buyers to be coming back around, and I would expect that strategic buyers will also be interested in deals as well. I don't know, Jessica, if you had any thoughts on that.
Yeah, no, that's very much the same I'm seeing. I had a pretty quiet beginning of year, which I think a few of us did. And it's definitely picking back up as we go into the fourth quarter. So,
And
Great.
yeah, hopeful that will continue.
Good news, yeah.
And to piggyback off of Mary's question, are there any industries in particular that you see are picking up in the M&A space? AI?
Yeah, I was gonna say AI. Although even for fundraising, the joke around town now is if you want to raise money, you have to put AI in your name or in the business plan, and that'll get someone's attention. Not so much in the M&A space yet, but I expect it.
So, yeah, we're seeing a lot of consulting deals. I think, services businesses seem to be a lot of what's on my desk right now, but being in San Diego, we're somewhat industry agnostic, so we always have kind of an interesting mix, and I think that's continuing.
If you can stay one more minute, there's an interesting question in the chat. It's
Sure.
what are recommended guardrails for conducting IP diligence while tempering the risk of IP contamination? I think he might mean contamination in that you know too much about a third party's IP.
Yeah, so that's where something like a clean room may make sense, only exposing certain members of your group.
Outside counsel, I guess.
Yeah, outside counsel is probably going to be the one to tell you. That's the first thing that comes to mind for me.
Is a clean room, yeah. I think that's typically what we would see relied on, but I do think, depending on your industry, certainly, and how critical IP is, it can be very important diligence. We didn't get into it much because it's a pretty specified area that, we personally don't dig into much, but it's definitely an area where you want someone with that specialized knowledge to come in and really figure out, what's there and ownership and, infringement issues, and yes, but definitely having a clean room, I think, is the way to address it if there's concerns about, trade secrets being shared and that type of.
In the life science arena too, again, being in San Diego, we have a fair number of life science deals, and those, a client may not want to share its crown jewels in the earliest of stages. If it's all patented, great, but if it's not been patented yet, if it's still kind of subject to trade secret law, then yeah, I mean, even under NDA, a client, and I will counsel a seller, like, look, if these are the crown jewels, even under NDA, you probably won't want to wait to share them because it's just critical to the success of your business, and that sort of thing is important in the life science arena.
Oh, sometimes the buyer doesn't want to see it either because they don't want to be accused later of copying or
Right.
Oh, I've got another question, if you don't mind.
Sure.
What deal values are you typically seeing taking advantage of RW insurance? And then is there a minimum threshold where it makes sense versus accepting risk of no seller indemnity deal?
I take that one.
Sure. So I think when we think about a minimum threshold, it's shifting a little bit. Paul and I actually did a presentation last year on rep and warranty insurance, but we still tend to use the number 20 million, I think, as the threshold. I don't think that's shifted much over the past couple of years. So if your deal is smaller than that, there are insurance options available, but we don't see them often, I would say, involved.
Smaller providers.
with smaller providers. But yes, it is, that's kind of beyond the scope of today in terms of, but that can obviously have a large impact on diligence as well, because now you have a third party coming in to do diligence. So that sort of just doesn't necessarily make the entire process take longer, but it certainly can increase the level of scrutiny, that even you as the buyer might care to do yourself. And so, but yeah, I would say $20 million and up, it's definitely something that you should be thinking about and looking into as a potential option, even as a strategic buyer, and considering whether it makes sense for the transaction.
By and large, our seller clients like it. They would probably appreciate it if it were offered by the buyer. But the thing that comes to my mind when I'm dealing with the strategic buyer, we haven't seen it, at least I haven't seen a ton of deals that are strategic that are using insurance. And part of that is I think you have to ask yourself and the other members of your organization, like, do we feel like we're going to be organized enough? Are we going to be efficient enough to be able to present our diligence product to the insurance company? Because they're going to ask for a relatively polished memo to understand what has been done so that their people can do the diligence on your diligence. And when I have a strategic buyer, and if it's clear they haven't done a lot of deals, I will tell my client, like, I'd love to get insurance on this deal, but I have a question in my mind whether this buyer can actually pull it off. We had a buyer agree to do an RWI deal last year. So our client got very comfortable with agreeing to more broad representations, for example, on the sell side, thinking that it was going to be covered by insurance, only to find at the end of the process that the buyer was not able to present that polished diligence product to the insurance company, and we ended up having an escrow instead. So that was painful. But yeah, it's a question kind of for you to think about. Do you think we can kind of get over the bar? The more you do it, the more comfortable you'll get, about what the process looks like. The first time might be a little painful.
Great. Thank you so much for your time. That was a great presentation.
Thanks, everyone.
Our pleasure. Good to see all your names on the screen.
Thanks. Bye-bye.
Thank you. Bye.